Thanks for joining us today to learn more about applying rights statements to your digital collections. Many of us are the transition to mostly remote service delivery and are knee-deep in the rollout of outreach strategies and instruction that leverage existing archival materials during the pandemic. Implementing rights statements has significant benefits to DPLA, the network, and a potential set of downstream consumers of data from DPLA. A large majority of the questions that come into the DPLA info email are from visitors asking about item usage and rights. These questions give us an opportunity to explain how the Digital Public Library of America is an aggregator of digital content and that we point back to the library where the material is originally housed. And then we lead them to determinations about the rights for individual objects. We encourage contributing partners within DPLA's hub network to assign a rights statement or Creative Commons license to individual items and relevant metadata fields. Today's webinar will provide an introduction to standardized rights statements 101 style. Presenters for this webinar include members of the DPLA Rights Statements Working Group, many of whom are currently implementing rights statements for the collections they manage. They will share their expertise and experiences as well as a wide range of resources for implementation. The Rights Statements Working Group is charged with supporting the DPLA network in the implementation of standardized rights statements by creating a place to share resources, coordinating training efforts like these, and establishing and managing a process for review of rightstatements.org statements. A recording of this webinar will be made available to all who registered afterward and posted to the dp.la pros site on the webinar page and workshops page. We ask that you ask your questions in the Q&A box in the toolbar at the bottom of the Zoom window. We'll monitor the chat and speakers will answer questions throughout the presentation and at the end. And now to our presentation for today. Julia?
Thank you, Shaneé. Just a moment while I start screen sharing. There we are. Welcome everyone, and thank you for joining us once again. My name is Julia Simic. I'm the Assistant Head of Digital Scholarship Services at the University of Oregon Libraries, and am a member of the Rights Statements Working Group. Today, I am joined by a number of my colleagues also on the working group. Greg Cram, Director of Copyright Permissions and Information Policy at the New York Public Library. Wendy Gogel, Manager of Digital Content and Projects at the Harvard Library. Gabe Galson, the Technology Projects Librarian at the Temple University Libraries, and Molly Huber, Outreach Coordinator for the Minnesota Digital Library at the University of Minnesota. Each of my colleagues will be presenting in turn, and as Shaneé said, we will have some time at the end for questions, so please add your questions to the Q&A box when you think of them. If we happen to not get to your question today, please feel free to email the working group at the address you see on your screen, or you can find information at the Rights Portal, which is a site put together by this working group with resources on copyright and rights statements. Today, we'll be talking about rights statements and what they are, and the benefits of using them. And we'll also be giving you some resources for implementing rights statements and some challenges that you're likely to face. With that, I will hand it over to Greg to get us started.
Hi, everyone. So before we can answer the question about what are the rights statements, I'm going to start with a different question. And that's a simple question that cultural heritage institutions are regularly asked, not only by our administrators and by our own staff, but by patrons who are coming to us to use our collections. And that question is, can I use this? As a library, our mission is to inspire the creation of new works, new information, new aesthetics and insights and understandings to advance the progress of knowledge in society. We execute on this mission by making our collections as broadly available as possible and primed for use and reuse. One way we encourage the use and reuse of our collections is to be clear with users about what we know about an item, including its copyright status. Next slide, please. So in 2010, there was no standardized way to communicate the copyright status of our objects to our users. Instead, most metadata systems had a free text field for rights metadata that looked something like this. It was a blank and foreboding field. Users were left to fend for themselves and navigate all of the different statements that we were using. Next slide, please. Although this was a problem, it was spread across cultural heritage institutions, it remained mostly a local problem. But it became a significant problem when collections started to be aggregated together in collections like DPLA. And it's not just US aggregators, but aggregators like Europeana in Europe and Trove in Australia. They were all aggregating this content, and they were bringing together metadata about our collections. Next slide, please. Between DPLA, Europeana, and Trove, the three main aggregators, we have data on over 100 million items. So we're doing, a pretty decent job at aggregating metadata about our collections so our users can search all of our collections in a single place. But where we're not doing such a great job is sharing with users what we know about the copyright status of our collections. Step back for a minute and think about a user encountering 100 million items from thousands of contributing partner institutions from across the globe. Users who want to use this content in a manner consistent with copyright law are asking us tough questions. They're encountering these items and asking things like, can I use this? Is it in copyright? Who owns the copyright to these items? Those kinds of questions because they want to get at, can I use this item? Next slide, please. So of the 35 million items in DPLA, contributing institutions had used over 100,000 different rights statements to describe their assets. This is a visualization that we'll talk about again in the next presentation of those statements, just to give you a sense of how messy it was to encounter all of these different statements. Each box represents its own unique statement. Another way to measure how well we were doing about communicating copyright status is looking at the number of words we were using to describe the collections. 25% of the words that contributing institutions were using were concentrated in a single field. And you would hope that that field would be in the description of the item, but actually only 22% of the words we were using were in the description field. 25% of the words that we were using were devoted in the rights statement field alone. And so let's take a look at how a few of those statements that were in place before rights statements began in earnest. So next slide, please. This statement is from our friends. It is a very long statement. In fact, it is such a long statement that I can't even show you the item on this slide. The text in this is dense, and as a user, if you encountered this item, I'm pretty sure you would just go to the next item if you wanted to understand the copyright status of the item. Next slide, please. This is a map created in 1787. I am confident that this map is in the public domain, but next slide. You'll notice that there is a digital copyright 2013, all rights reserved. The Rights Statements Consortium believes that no new rights are created when digital photographs are taken of cultural heritage works when the intention is to slavishly copy the original. So when my highly experienced photographers in our digital imaging unit take photographs of our collection items, no new copyright is generated in our photograph of that object. But in this case, we have a map that was in the public domain and someone asserting a copyright in the digital photography. Next slide. This one, here, some materials may be protected by copyright, and I'm not sure exactly what that means. It means there may be some restrictions imposed by donor agreements or other things, but you as a user wouldn't know where to look for those restrictions. And although I only picked 3 of these for this presentation, I created one of those very unhelpful statements and applied it to all of NYPL's digitized items. In fact, one of the biggest boxes on that slide with all of the different statements came from me. So we're not immune from this. With all of these problems in mind, though, a group of DPLA and Europeana contributors came together to work out this problem, to solve this issue of multiple unique rights statements not really providing a benefit to users. And the first obvious place for us to look was the standardization effort brought to us by Creative Commons. So skip a slide and then another slide. So let's talk about Creative Commons. So Creative Commons provides a set of licenses that allow creators to communicate which rights they reserve and which rights they waive for the benefit of recipients or other creators. And these licenses from Creative Commons are applied by the rights holder. Next slide. There are 6 flavors of licenses where the rights holder retains some rights but grants users a license to use the works in certain ways. The licenses range from a simple attribution is all that's required. You just need to give credit for your use, all the way to something much more restrictive, which would be a non-commercial, no derivative and share alike kind of license. So there's at least 6, there are 6 flavors of Creative Commons licenses. At the next slide, there's even a variant that's not exactly a license, but is instead really a waiver of rights. And that's the item on the left, that's CC0, otherwise known as the public domain dedication. It's a rights holder who is the one who dedicates their works to the public domain using this CC0 dedication. But on the right, there's one more CC product that adds a little bit of confusion here. And that's a tool that's not used by a rights holder, but is instead used by a third party to describe the copyright status of the item. And that's the CC public domain mark. It's been interpreted to mean that we should only apply this public domain mark to things that are in the public domain worldwide. We have enough trouble deciding what's in the public domain in the US. Applying this to 192 other countries may be pretty difficult. So that may be why the public domain mark is not used very heavily. Next slide, please. So cultural heritage institutions are often not the rights holders and therefore can't apply CC licenses. Cultural heritage institutions want more granularity on the public domain jurisdictions. They've agreed to certain restrictions on use, and they've negotiated reuse rights, but aren't necessarily compatible with CC licenses. That means there's a hole we need to fill. Next slide, please. And that's where rights statements come in to fill in these gaps. There are 3 main flavors of rights statements: the in copyright, no copyright, or not in copyright, and other. And I'll walk you through the kind of flavors pretty quickly here. So next slide. We'll start with in copyright. In this category, you'll find the basic in copyright statement, a couple of orphan work statements, and a few statements where the institution who's applying the statement has secured permission from the rights holder to allow downstream users to make specific uses or specific kinds of uses, things like educational uses or non-commercial uses. Next slide. There's a no copyright category, and in this category, you won't find a generic public domain statement, at least not yet, but you will find a no copyright United States statement to acknowledge the differences between US law and the law of basically every other nation when it comes to the public domain. There are also flavors of no copyright, but other restrictions apply because sometimes institutions agree to limit downstream uses of digital objects in exchange for digitization services. We needed statements to accommodate those kinds of more basic uses restrictions that we've seen in the past. Next slide. The last category is undetermined. And in this category, you're going to find statements that provide less information about the copyright status of the item, but more information about the level of certainty that an institution may have. It's usually used to describe the level of certainty around an item's status. The statements include things like copyright not evaluated, which means that we didn't even look, or we looked, but we didn't make an evaluation, all the way through no known copyright, where the institution who's applying it believes it's in the public domain, but doesn't have definitive proof that it is. These statements are both human readable and machine readable. And as these statements are adopted by more cultural heritage institutions, we predict that users will become more familiar with the statements and solve the morass of 100,000 unique statements. So I'm going to turn it over to Wendy now to talk more about the benefits of adopting these statements, and we'll have more questions in the Q&A. Wendy, over to you.
Thanks so much, Greg. Hi, everyone. I'm Wendy Gogel from Harvard Library, here to talk about the benefits of using standardized rights statements. The implementation supports open access by providing cultural heritage stewards a way to identify and mark items from our own digital collections, all for sharing while respecting the law and rights of rights holders. Greg already spoke a bit about the primary benefits to users, but I'm going to cover that again because it was part of the challenges. The primary benefits are to users when we do this work to promote use and reuse of digital collections by consistently and clearly communicating rights information. Standardized rights statements provide answers for users to the questions, as Greg mentioned, can I use this and how can I use this? For items such as this early 19th century primer, this watercolor of Rome, this cyanotype of a botanical specimen, or this colonial period letter, a researcher would be able to determine if they need permission to publish or teach or copy and frame one of these items without them having to study copyright law or ask us. Standardized rights statements in the metadata for each item drives this powerful search feature for the New York Public Library digital collections that enables limiting a search to only public domain material. Of the almost 900,000 items in the NYPL digital collections, more than 300,000 are in the public domain and can be used by anyone for any purpose, and this is very clearly conveyed in their user interface. The same standardized rights statements metadata enables faceting to refine search results to only public domain material after a search. So you actually can search for everything and then facet to focus only on materials in the public domain, just like this search for zoology shows. The statement from rightstatements.org appearing in the item level metadata alongside the digital object makes the status clear to the user. In the Minnesota Reflections digital collections, the Northfield Historical Society displays the icon for the statement no copyright, United States, and the text and URI in the metadata provide additional explanation in both human readable and machine readable form, making it clear that the item is in the public domain in the United States. Equally important, it is clear when an item is in copyright and its users are limited to those allowed by copyright law. The interoperability and standardization of standards rights statements mean benefits for aggregating collections, engaging in collaborative work, and enhancing our ability to work at scale. The statements have been designed for both human users and machine users, such as search engines. They conform to semantic web technology and are also now available in multiple languages. And I know that Greg showed this a little bit earlier, but in our cultural heritage institutions, rights metadata has grown over time through different standards and for different purposes. Initially, it was never intended for network connections, which could not have been envisioned when a lot of this metadata was created. Now, however, it is clear how earlier practices don't work in the networked environment. As this visualization shows, this represents, as Greg said, the more than 100,000 different rights statements on items contributed to DPLA in the first year that they launched. Since this is confusing to users, DPLA contributors are now making a concerted effort to use standardized statements to address this. This work is often required for sharing digital collections with aggregators like DPLA and partners and collaborators like the Library of Congress and Bibliothèque Nationale de France. The benefits of an aggregator like DPLA for a user are clear. They provide a single discovery location for almost 40 million digital items from over 40 partner organizations so that users don't need to repeat searches in each of these organizations' user interfaces separately. There are other new and innovative uses made possible by the interoperability and automation capabilities of rights statements. More and more organizations are providing APIs to their data, just as DPLA does, which allows working at scale in ways that are otherwise impractical. The machine-readable standardized rights statements enable parsing, selecting, and combining data that is free to use and reuse in all kinds of new ways, from data mining and collections as data to projects as the DPLA Wikimedia project. In an effort to make artifacts from cultural heritage institutions more accessible to all, DPLA is contributing digital assets to Wikipedia Commons, which requires rights statements. Digitized collection items receive 10 billion page views annually on Wikipedia, and so DPLA is trying to tap into that audience to increase usage. As of this Monday, July 20, there were over 700,000 files uploaded, a scale that could not be achieved without the interoperable and machine-readable rights statements. I hope you've been able to see some of the benefits to the use of standardized rights statements. And now I'm going to hand the mic over to Gabe Galson to talk about resources for implementation.
Hey, this is Gabe Galson. I'm a technology projects librarian at Temple University, where I led an implementation of the statements. I promote their use statewide through PA Digital, DPLA's Pennsylvania hub, and through DPLA's Rights Statements Working Group. I created the PA Digital Rights Statement Selection tool, and along with my co-presenters, I'm continuing to build out the Rights Statements Working Group's rights portal site. And I'll show you both of these resources in a minute. In this section, I'm going to introduce some tools and resources that can make the implementation process easier. There are already an array of excellent resources available. However, in the past, there were access and discoverability challenges. Formerly, many resources were difficult to locate on the open web or were accessible only to those already involved in the work. Furthermore, there was no one directory that sought to collect all of these resources. Next slide. Let's start with the resource created by this group, the Rights Portal. This website aggregates and makes discoverable statement implementation resources. Next slide. The resources it collects are listed through this table, which is searchable and is facetable via several categories. Next slide. It should be said that one reason rights statements implementation can be complicated or a little confusing when you're starting out is that this process can be conceptualized as a number of distinct steps, not all of which your institution may need to undertake. For example, there's copyright status determination, figuring out the copyright status of an individual object or collection. There's right statement selection, determining based on best practices which rightstatements.org statement or Creative Commons license to apply based on an object's copyright status. Then there's risk assessment, the evaluation of the institutional risk that you're assuming when digitally disseminating a given object. No one resource covers all of these steps comprehensively, but the Rights Portal seeks to clarify which resources can be used for which steps. Through the keywords facet, you can isolate resources relating to a specific implementation step. Through the type facet, you can isolate resources in a particular format. Is it a video? Is it a graphic? A text guide? An article? You can also facet by institution and browse by resource creator. Slide. Here are some widely used resources collected by the Rights Portal. We'll start with charts and visual tools. While all of these resources are similar in their format, they differ in their scope and in which implementation steps they apply to. First, we have the hurdle chart, a comprehensive and authoritative guide to copyright status determination, updated yearly. Next slide. This is Minnesota Digital Library's Rights Review, which Molly worked on with other MDL colleagues. It overviews the subset of statements approved for use through the Minnesota Hub and covers both copyright status determination and statement selection. It's also used widely to promote their workflow statewide. and make it easier for contributing institutions to implement. Slide. This is the right statement selection tool, which I made through PA Digital in consultation with Brandy Carl. It comprehensively covers statement selection, overviewing each statement and its correct usage, and its legal logic is meant to apply nationally. It also includes clickable links to each statement when viewed in a browser, allowing it to function as an alternate right statements.org interface. Next slide. This is UMiami's assigning statements matrix, which covers copyright status determination and statement selection, and includes workflows for both US and Cuban copyright. Next slide. Finally, for the visual tools, this is Orbis Cascade's right statements decision matrix, which also spans status determination, statement selection, but also touches on risk assessment by including more cautious and least cautious options for statement selection in certain situations. Next slide. The Rights portal also indexes many video resources. For example, this Intro to Rights Statements video from Brandy Carl and Linda Ballinger of PA Digital. Next slide. And here I've listed some essential text resources that you should definitely take some time to explore if you want to know as much as possible about the statements. And this certainly isn't all of them, but these are some highlights. Note that all of the resources that I highlighted here are linked through this presentation, as well as, of course, through the Rights portal. So if you want to see any one of these in particular, you can through this presentation. Slide. Finally, it should be said that the cultural heritage copyright community itself is an amazing resource. The Rights portal includes a community connections section that aims to bring those interested into existing practitioner networks. It will also soon include an events calendar, as well as other in development features. And if you do want to become a member of the implementers listserv, suggest another resource, receive rights-related update, or ask an implementation question, email us at this address to be added to the listserv. And now I'm going to hand it off.
Hello. My name is Molly Huber, and I am the outreach coordinator for the Minnesota Digital Library, and I'm going to talk to you about some implementation challenges that you might face as you move towards getting rights statements implemented in your collection, or helping others implement rights statements in their collection, as the case may be. One of the first kind of almost barriers is just this widely different levels of knowledge around copyright and rights statements. So you often end up having to spend a lot of time just kind of bringing your stakeholders up to speed on what these things even are and what they mean, and getting everyone to a common understanding. And part of this is, growing out of this maybe, is there's also a lot of confusion sometimes between rights statements and licenses. Greg spent some time earlier today talking about Creative Commons and what those different flavors of licenses are. And sometimes there's some conflation between Creative Commons and rights statements, but rights statements are not licenses. They're just descriptions, they're labels, they're metadata. They are just something that gives you additional information about the status of what you're trying to describe. They are not licensing use, they have no legal bindingness. That's not a real word, I know, but just to make clear that they are really just description and an addition to your metadata. Another common problem, even now, is that people believed that 1923 was somehow a magic year, and that everything after 1923 was in copyright, and everything before 1923 was magically not in copyright, which was never actually true. That miscomprehension arises out of just the peculiarities of United States copyright law, and it really only ever applied to published works anyway. So unpublished works were not governed by that law. And we're under different conditions often. There is more awareness now, especially with the copyright year now rolling over every January 1st, that 1923 is not magic and fixed in stone, but there is still sometimes some education that needs to be done around that when you're working with stakeholders and contributors. Some time was spent above also on the shift to user focus, which sometimes, before, when we were thinking about rights, organizations were thinking about rights, they often were thinking about it from the can I use this perspective. But now we need to think about not only can we use this as an organization, but can our users use this? How can we encourage use? What is the benefits to them? So there's also some kind of difference in mind shift around the statements and why you label and why you put the information out there. And that stakeholder buy-in, I've kind of alluded to that a few times in all these different points, but internal and external is really important. You have to get everyone on board to implement the right statements. A lot of people don't see the value of it, don't see it as a priority, think it's going to be too much work. Internal, your internal lawyers, if you have them, might be worried. There's different kind of, you need to get everyone kind of to agree on the importance of it and why it should be done and how it should be done. And sometimes that can be a real challenge. So make sure you spend some time, set aside some time to work on the relationships and the communication to make sure that everyone is in the same place as you before you launch forward. Next slide, please. So then once you've decided that you are going to apply these rights statements, then there's some kind of application challenges that sometimes you need to get over or to think about, especially among archivists who've maybe been really buy into the less process, more product thing. There's this desire to apply statements more broadly or at the folder level, and that doesn't work as well for digital collections. Digital collections, when you're physically looking at a folder of something, you can page through and you can see and you can, so it doesn't have to be, there can be folder level information that's really valid and valuable and gets you where you need to go. But, in a digital environment, it's hard to search at the folder level. You need to think about each individual item. And rights statements are going to apply to individual items. They're not necessarily going to apply to a whole group. Sometimes they will, but sometimes things are not all created by the same creator at the same time period under the same circumstances, in which case they might have a similar rights statement. They're going to be, maybe it's a variety of things like a letter, a photograph, a program from something that's going to have a lot of different rights statements involved to it. So you really actually do need to spend the time to think about applying rights statements at the individual level. And it's not necessarily always as time consuming as you think. We found that you can often sort by, leverage your Excel spreadsheets if you have them, for example. You can sort through spreadsheets and figure out groups of things that aren't necessarily folder groups, but you can get the statements applied in that way. It doesn't have to be as challenging or intimidating as it sounds. Also, there's the issue kind of the statement of copyright not evaluated, which in the copyright, in the rights statements implementation fields can be somewhat controversial, just in the sense that it can be easily misunderstood. It is, if you're saying that the copyright not evaluated, and you're kind of, people understand that sometimes to mean that you didn't even look at all, and maybe you are saying that, but that's kind of, you probably have thought about what you're putting up online, at least a little bit, to think, even if you feel comfortable putting it up online. And it may be exposing you to some different risks that you may not be comfortable with, which kind of gets to my next point. So, and also sometimes there's a desire, kind of connected to my first point about the folder level, is like, well, I don't have time, so and I need to do a standardized rights statement of some sort. I'm just going to throw copyright not evaluated at everything, and I'll circle back later. Well, that's kind of a fallacy too. I mean, it may seem like an easy solution, but it's not as straightforward as it seems, and it's better to just take the time and try and get your rights statements the first time, rather than throwing a label on it and then trying to circle back when you think you're going to have more time in the future. Another big consideration when you're thinking about what rights statements to put on things is what your institution's tolerance for risk is, what you as an individual, but more importantly, what the organization's tolerance is. And one of the things that I love about the Orbis Cascade tool, for example, and we also tried to build into the Minnesota Digital Library tool, is sometimes you arrive at you go through the workflow, or you go through the questions about the object, and you arrive at potentially a couple potential rights statements that you could use. And you have to decide, well, this one's maybe a little more conservative. Am I more comfortable with that? Or this one maybe is a little more open. Maybe I'm more comfortable with that. So you have to, there's a lot of kind of individual and organizational deciding where you are at and what labels you're comfortable putting on. So taking time to assess the risk tolerance of your organization really makes a difference with rights application. Next slide, please. So finally, there are also lots of technical challenges with rights statements implementation. So as most of us, unless we're creating new digital collections now and can put the rights statements in right at the beginning, we're going back and we're working back over things that we've already done and our contributing organizations and our partners have already done. So we're all working with existing databases. Questions as basic as how do you get the statements in there? I mean, is it a small group? Can you do it manually? Do you have to use a tool? For example, at Minnesota Digital Library, we work with Content DM. So we're using a tool called Catcher to actually get the things in there for us. I mean, how do you get the statements in there? How many fields do you use? What fields are you going to use? Are you going to use, many organizations settle on 2 to 4. Kind of the basics, or you need at least the statement. That's the basic. A lot of them would also like the description because it makes a lot more difference. A lot better if you can describe what it is. Then do you allow a local rights field? What if you don't allow a local rights field? What happens to the information that was there before? A lot of times in the past, people would put contact information in their rights field, which I think we could all agree is not the right place for that, but you don't want that to be lost. Then do you create a different field? Do you move that over? There's kind of a lot of, what about a field for, your internal decision making? Do you, the steps that led you to making that determination, do you create a field for that? If so, is it publicly available? Is it a private field? Which kind of leads you into the mapping decisions too. What do you map to? Could you use Dublin Core? Do you use something else? Do you keep the local rights field, not map to it, just map to the standard rights field? There are a lot of kind of decisions that need to be talked through. And then the final one is, once you've made all those decisions about the fields and what's exported, how does the information display in the record? Wendy shared some examples from New York Public Library and from the Minnesota Digital Library about decisions we've made about where information displays. Obviously, MDL chose to have the statement right under the image, the graphic. And then farther down, you could get into this is the statement itself. Here it links to the rightstatements.org webpage. Here's the full description, but you might make a different decision. But you do have to spend some time with your tech team thinking about how is that going to come through? Where is it going to show up? And will you be able to fasten on it later, which is also really helpful. So that is the end of my implementation challenges, although I'm happy to answer questions, talk to people. But at this point, I'm going to say thank you to everyone and hand it over to Greg, and we can officially start the Q&A portion of our time today.
So we've been answering some questions in the Q&A as we've been going, but there are a few questions that are worthy of some more, all the questions are worthy of conversation, but a few that I want to pull out and highlight. One is, can you further explain no copyright but other legal restrictions? So those of us who have used that statement, who have looked into it, can you talk more about that statement and what it means? I'll leave it for Molly, Gabe, Wendy, Julia, whoever would like to go.
Could you repeat the question again, Greg? I'm sorry.
Yeah, further explain the no copyright but other legal restrictions apply. So some items may be donated with restrictions, but it's in the public domain. What does the other legal restrictions category mean?
I'm happy to take that first, and I'm sure others will want to include. So especially in special collections and archives, there are often additional agreements that are contractual obligations, such as a gift or donor agreement, or if a vendor or a funding agency is funding the digitization of a project for you, they may say, we will pay for this if we can maintain the rights for 1 or 2 years so that we could sell subscriptions to the material, and then the institution is free to share widely. So, so sometimes there are other legal restrictions that are local legal obligations that are locally engaged in. And that does bring up, I think, one of the things that Molly talked about, which is how you express both. You use the rights statement, and then somewhere you probably want to put a little bit more information about what the restrictions are and who to contact.
Great. And feel free to continue to add questions to the Q&A section. We'll keep going. If you've got more questions, feel free to add them. Molly, this question's for you. So if my institution owns the copyright in an item, the donor, for example, was the rights holder and assigned their rights to us, should we be using a Creative Commons statement or license or a rights statement to describe the object? And how do we make that decision?
I think, again, that goes to your organization's risk tolerance and comfort. That's kind of a local decision that you can make. That if, you know, we've kind of decided here at the University of Minnesota MDL that we're going to try and be as open as possible. And if we do happen to own the rights, we are putting creative licenses on things. But that's kind of up to you, like how open you want to make it for the users. There's not a best practices. There's not a determination. Both are equally valid. So it's your choice.
Great. Gabe, one of the other questions we received was about the in-copyright statements. So some folks are concerned that by applying an in-copyright statement, they couldn't contribute the item to DPLA. Can you tell us a little bit more about how those two things might actually work together, where an in-copyright statement may still allow something to go onto DPLA?
Well, there are many in-copyright items in DPLA. In some ways, it comes down to institutional risk assessment. Is the institution that wants to contribute the in-copyright item comfortable putting it up to begin with? If they're not, then it's not going to go up to DPLA. Another thing to note is that the DPLA doesn't host any images. It technically aggregates the metadata and then provides a link back to the image on the contributing institution's website. So I think that plays a part in that too. So basically, there's no obstacle directly tied to an in-copyright status that stops it from going up to DPLA. And you know, anyone else can elaborate on that, because there could be a little more to that.
At MDL, we feel that a lot of what is in copyright that's shared with us, and again, we have a lot of contributors, so they are making their own individual determinations, but that the purpose of the Minnesota Reflections is educational, nonprofit, so we figure it's fairly broadly covered under fair use. Nobody's making money off of it. Nobody's, you know, it's more just an educational resource. So that's some of how we approach the in-copyright things, or our contributors do.
Right. At Temple, for example, we have a big collection of newspaper photos that are all in copyright because they're from the 40s onward. But Temple has an agreement with the newspaper that they can put them up, and that was you know, set down in some kind of agreement. So that also can be a situation where you feel comfortable putting something up because you have the tacit approval of the copyright holder.
Great. The next question is around the in-copyright educational uses and in-copyright non-commercial uses. Emily would like to know, in which situations should we use one or over the other, and how do we get to the point of knowing that we can use that statement? So I'll leave that Molly or anyone who'd like to answer that one.
I'm sorry, I was looking at a question in the Q&A.
Sorry.
Say that again.
The difference between copyright educational uses and in copyright non-commercial uses. How do I know as an institution which statement I can use, and how do I get to the point of being even able to apply that statement?
I'm sorry, I'm not a good person to answer that because we don't use any of those three statements in MDL. None of the things that are contributed to us meet those criteria. So we actually, again, it's a local choice. We actually only use 6 of the 12 statements at the Minnesota Digital Library. So because the other ones just don't apply to our situation. So I'm sorry, I can't really help with that question.
So it is a local choice, and but I could help a little bit with the difference between them. So since we're talking about material that is in copyright, is that correct, Greg?
Yes.
So if we're talking about material that is in copyright, you can think about somebody applying a fair use criteria to a library exception first, a library and archives exception that we could make some copyright material available, but then a fair use criteria to looking at how it could be further used. And one of the things that we would do looking at our material is say, okay, is this something that if it is used in an educational environment, in other words, for teaching or for research for an individual at an individual level, then we should let people know that that it is in copyright, and we don't want you to be concerned about infringing copyright. So a fair use would be educational use. The other non-commercial is that one of the criteria you have to look at in fair use is whether somebody is making money or not off of the use. And so it's a way of an institution saying, since we're thinking of this as fair use, probably better not to use it commercially, because that could be an infringing on copyright criteria. So it's just sort of putting up a way of saying, even though this is in copyright, we believe that both educational uses and any non-commercial uses may be fair. And Greg, I'd love you to comment on that since you actually are a lawyer.
No, I think that's right. Fair use, we could spend another hour on if we wanted to, but we don't. We only have 11 minutes left. So there's another question that came in. There's a few questions that come along the line of implementation, and so this panel has implemented and adopted the statements. So one of the questions is around how much time does it take to apply rights statements to collection items, and we've talked a little bit about how to go about that work, but what does it look like on the ground? How long does it take to do this work, and assuming you have an institutional buy-in?
Not nearly as long as you think. A lot of it helps depending on how similar the items you have are. If you have a nice big collection of black and white photographs all taken about the same time, that's going to be a breeze. And you'll maybe find that like the 80% of it is actually going to be a lot faster than you think, especially once you start working through some of these tools that have been developed. You learn what questions to ask, you learn what basic things apply. It goes usually pretty quickly. And as I mentioned earlier, kind of under implementation, if you have things in a spreadsheet, you can kind of leverage your spreadsheets to sort it by similar items and then realize, group them together, which it helps if you can kind of do a group at once. And that group, like I said, might not be a collection or a folder level group. It might just be similarity group. There will be some at the end that take a little longer. There's always going to be some that, it's hard to find out information about them. So, but that's probably only going to be like 10 or 20%. So you're going to be able to get a bulk of it done probably pretty quickly. And I can't really, when we first started doing implementation MDL, we were asking our contributors to do estimates of hourly counts. We thought that would be a helpful thing to think, and there's no hourly count really I could share with you. They came back, they all said, no, it's impossible. I'm really sorry. We just can't tell you the exact amount of time, but they all agreed that it went faster than they thought, and that it's better to do it in chunks, not just in chunks, but also chunks of time. Like, don't do one at a time, don't do 3 at a time. Set aside actually like a morning and do a bunch, because then you get going faster and it's in your brain and you go more quickly. So set aside chunks of time to work on it. It actually does go faster than you think it will.
I'll say from the New York Public Library's implementation, for a long time, we had a large backlog of items to get through to apply statements. Something like 1.5 million objects that we needed to apply statements to. We got through that backlog. There is less than, I think, 3% left in that backlog, and those are probably the hardest 3% that we have. We did all of that work with essentially 2 or 3 full-time staff who were not doing this full-time, were doing other things full-time. And it probably took us at least a couple, I think it's probably 2 years or so, but it's hard to give you exactly how long it takes per item. But it is something that you can batch. It is something that, especially collections that are very homogeneous in terms of a rights issue, are very simple. So you could do 20,000 items in one shot because all of the items were published before 1923 or 1924, and it's very simple and straightforward to be able to make that single application to many items. Others, how has implementation been going for you, and how do you feel? What do you feel like the workload looks like for your teams?
At the University of Oregon, we were fortunate to be making a system migration. At the same time, we were remediating all of our metadata at the same time. And because we had thought ahead and started fixing our metadata holistically in big chunks, not just in collections or in our different silos, we were able to do just what Molly said. We exported our data, chunked it out, did some color coding when we saw like things, and just did mass replaces. It actually only took us a couple of months with like 2 people who were working maybe half-time altogether.
Great. Another question about the rolling public domain. Now that the public domain is moving forward every year, how are we addressing that challenge within our databases? Are we going backwards and fixing those? Are we setting kind of expiration dates? How are you all tackling that issue?
I so wish it was automated. So far, there's no automated way to do it. Believe me, we've looked. We're doing it manually. We are actually, one of the fields, I talked about the number of fields. One of the fields that we decided to have our contributors include was expected public domain year of entry is what we actually called it, even though we really mean no copyright United States. When we say public domain, we don't mean public domain, but we actually have that as a field. And so that you can say when it's going to come out of copyright, and we are going to every January manually search through that field and find it and see what needs to be turned over. We'll see if that works, but that's our plan for now until there's a better tool in place. So we're going to do about once a year, and we're going to go through and we're going to sort on that field and see what has changed in the last year.
We're in the same boat. We would love to automate it, but we just can't do it right now. So the plan right now is every January we will do a mass search and pull the records that we think we'll need to update, and then go through those by hand before replacing our information.
Great. Molly, you've been working with MDL's implementation. We have a question from Megan. As we're working with our contributors to implement the standardized rights statements, is it problematic to have repeated rights statements fields where one field is their non-standardized local statement and their second field is the controlled rightstatement.org statement or URI? Is it better to kind of harmonize them and have one field, or can I continue to have a local field and a rightstatements.org field?
You can, as long as they don't contradict each other. And that would be the main thing. You'd want to make sure that the local rights field does not contradict the information in the standardized rights field. And you don't want to merge them, because the standardized rights field are standardized rights field. That's the beauty of them. That's what they're supposed to be. You shouldn't change those. If you want to have a local rights field or something with more information, that's fine. But again, we want to be clear to the users and not provide them with contradictory information. So it's real important that whatever local information there is in harmony with the standardized information.
Right, and some hubs really strongly discourage local statements. Some don't allow them at all, and others don't say something about that one way or another. So what I've seen is that sometimes retaining a local statement that might do something fundamentally different from a standardized rights statement can really help you get institutional buy-in or to get people on board. So one way to think about it is that the local rights statement, you don't even have to call it that necessarily. So yeah, that's my take on that.
Great. We've got a few more questions about how do we do this work? So we know we need to apply the statements, but we've got questions. Like I've got postcards, and I need to know more about how to evaluate the status of those. Where should I go, and what should I be doing? Or where at least should I start? Gabe, I'll leave this one for you. Where should we begin? Oh, I think you're on mute, Gabe.
I don't see the question on cue. Can you just read it?
Sorry. Yeah, so I want to dig into this issue. I'm an institution who now is motivated to apply rights statements. I need to know more information, though, about how to determine copyright status of collection items. Where should I go? Where should I start?
I would start personally with the hurdle chart, which is an amazing resource. And then I would proceed through some of those visual resources, which I think will also break down the sort of decision points that let you determine status determination, or let you determine right status. And from there, I would read into the conditions on statement application. So that's sort of why I structured the resources section in that way. That's how I would suggest proceeding through that process. So figure out whether they're in copyright, out of copyright, undetermined, and then go from there.
All of those resources Gabe mentioned, plus many more, are available at the rights portal that's on your screen right now, the rightsportal.dp.la. Our team spent over a year, so you didn't have to, digging through all the resources, trying to find everything we could, and we're still adding resources. So if you have resources you develop locally that you think are a good fit for that portal, please share them with us. But they're all there in one place, so you can get started, and as you learn more and need more additional information, you can keep searching through there, and that has it connect you to anything that you might need related to rights implementation.
Great. Well, it looks like we have, we're just 1 minute shy of our time. So on behalf of all the panelists, I wanted to thank everyone for coming today. We will share the slides, so you'll have those, but do take a look at the rights portal. This was a labor of love to put all of these resources together, and I think it's a great place to begin.
Thank you all for coming today.